Hi, this is Andy Katz, host of March Madness 365, presented by Grammarly. This week on the podcast, listen as we break down the latest AP poll and give you insights on my updated Power 36. Listen to March Madness 365 with Andy Katz, presented by Grammarly, wherever you get your podcasts. Grammarly is a secure AI writing partner that gives your team an instant first draft in a few clicks, not a few hours. Companies that use Grammarly save an average of 19 days per employee per year. Grammarly works seamlessly across 500,000 apps and websites. Get personalized on-brand writing help everywhere your team works. Learn what better writing can do for your company at Grammarly.com. Grammarly. Easier said, done.
They were probably panicking because they had the event the next day and they didn't know.
I can understand that, but not even from Charlotte.
There should still be compassion.
Yeah, because she was in the hospital. She had surgery. I reached out to her. I said, this call is not about business. It's about friendship.
This is the plaintiff, Charlotte Key. She says she hired the defendant, a DJ, to play music at an art festival in Brooklyn, New York. Paid him, and the guy blew her off. That's right. He didn't show up for the event. Never even communicated with her. She's rip-roaring mad and wants her $398.99 returned and is suing for just that today. This is the defendant, Joseph Clark. He says he had a medical emergency, was rushed into surgery, and tried calling the plaintiff's associate to let her know there was a problem. He also called the plaintiff to tell her he was in the ER, and she showed zero compassion for him, told him she was going to hire another DJ. He said he'd fulfill his contract at her next event, which was the very next weekend, but never heard from her. Bottom line, the plaintiff was the one who breached, and he owes her nothing. He's accused of letting the music die.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Milian in our forum, the People's Court.
Be seated. Come to order, please. Litigants have been sworn, Your Honor.
Thank you, Douglas. Okay, Ms. Key, acting as president of the Fulton Art Fair Incorporated, you are suing Joseph Clark and Groove Control Entertainment for $398.99 that you want him to return to you because, according to you, he breached a contract to DJ for an event. Tell me what happened.
What happened was we have our annual event, which is we're going to our 58th year on the fence. It's an outdoor art exhibit. We've been
58th year on the
fence. It's called On the Fence because the artwork is hung on the park fence all around the park.
Okay. Now, you were having an event, and what dates was that event going to take place?
Last year's event was June 13th, 14th, 20th, 21st, 27th, and 28th.
Okay. So it's every weekend, Saturday and Sunday, for 3 consecutive weekends?
Yes, ma'am.
Is that always the way it is?
Yes, ma'am.
Okay. How does it, when it gets on the fence, I'm just curious, it gets on the fence each morning, right? It's like any other art fair where if there's a weather problem, it's just not going to happen.
Yes, ma'am.
Okay. All right. So, were you president in the summer of last year?
No, ma'am. This is what caused all this confusion. Unfortunately, our president, Ms. Annette Brown, very well missed. She really pulled this organization together. I was the treasurer at the time.
Okay, so Ms. Brown is the one who actually reaches out to you, right?
Yes.
No, and you had known Ms. Brown for how long?
For a good while. Actually, I was friends with her.
What's a good while? I don't know what that means.
Actually, about 2 years. I was real friends with her sister.
Okay.
And
so she reaches out to you. Had you ever DJ'd this event before?
Yes, I did 2014.
All right. And how much were you paid in 2014?
Underpaid.
Well, how much were you paid? You have to answer my actual questions, okay?
I believe it was $700 something.
Okay.
Yeah, $700.
And did you DJ for all 3 weekends, 6 days?
All 3 weekends, and it went well.
Okay.
That's with the old president for 2014.
And wait, was that someone other than Annette Brown?
Yes, Annette Brown came aboard just this 2015.
Okay, so she reaches out to you, or someone else reaches out to you?
No, Annette Brown reaches out to me.
And says, will you DJ this event?
Right, she said, I was reluctant to do it because I told her last year you underpaid me for the hours of service
What are the hours of service?
The hours of service from 12 to 7 on Saturday and from 12 to 6 on Sunday.
Okay.
So when Annette called me and she says, well, listen, you know what? Would you consider doing it? We'll get you $1,500. I said, that's still being a little underpaid, but I'll do it for the sake of our friendship.
Okay.
Okay. And then it was like, okay, you know what? Prior to the other president from last year, she either sabotaged the paperwork, because, of course, they get a grant. So the paperwork.
So the grant didn't come in for the year that Annette asked you for.
Right. The paperwork didn't go in on time. This is what Annette is telling me. So
after or before you agreed to do it?
This is before. Okay.
So she tells you, listen, we don't have the money for you, but we'll have it when?
September.
Okay, so you agree, stop. So you agree to do the event in the summer in June on the dates that she said, with the understanding that you would get paid all of it in September, or a part deposit now, which is the subject of this lawsuit, $350 then, and then the rest of the $1,500 you would have to wait until September for.
Right.
Okay. All right, hold on. Go ahead. So now here comes the first dates of the show, and what happens?
What happened was June 13th was our first weekend of the event.
Okay.
Me and Ms. Brown tried to reach out to Mr. Clark that Friday, prior to the Saturday.
Okay.
We could not get any communication from him.
What does that mean? You left messages and he wouldn't return them?
I can't remember whether she left a message or she couldn't leave a message. But we reached out. I was with her like all that day. We tried at least about 2 or 3 times to call him with no response.
Okay. Now, there was already a plan that he would show up at a certain time and place with his equipment and everything else, right?
Yes, ma'am.
Okay. So then what happens?
That evening, Joseph Clark reached out to me.
Oh, to you?
Yes, ma'am.
Okay. How did you have her number?
I believe we have been communicating from the last event.
Why is it, if you told me Annette was the one who hired you, why are you calling her?
Because when I called Annette, she wouldn't pick up the phone. I was in emergency.
Okay, what had happened to you?
What had happened to me, I went to see the doctor that Friday, prior to the event, and I had gangrene in my toe, and he told me, you have to go into emergency right away. He said, you got enough time to go home, get what you need to get, and you get back here. You have to go to emergency right away because it could easily spread. So I'm shocked. I'm trying to get my...
Are you diabetic?
Yeah.
Okay.
So I was trying to get my normalcy. So what I did was, first of all, when you go into emergency, you have to wait till they get your room. Have the phone. I couldn't get a signal downstairs, so I had to wait until I got upstairs to the room. So I get up to the room finally. I called Annette a few times, and she didn't pick up. So finally, I called Charlotte. Okay. And I told them, I'm in emergency. I don't think I will be there tomorrow. Would you be able to get another DJ? And it's like, pause for a minute.
What ended up happening with you? Did they actually have to amputate the toe?
Yes.
I'm sorry to hear that. So clearly you did not work that weekend.
No, I did not.
Did you let them know that night that was going to happen?
I wasn't really looking to receive no compassion about my situation.
Well, did you feel like you didn't receive compassion?
No, and the thing about it, that
Not even from Annette?
Not even from Annette. Not even, especially from Charlotte.
They were probably panicking because they had the event the next day and they didn't know how to
I can understand that, but not even from Charlotte.
There should still be compassion.
Yeah, because she was in the hospital. She had surgery. I reached out to her. I said, this call is not about business. It's about friendship.
All right, let's talk about that weekend. Obviously was shot. And that weekend, did the fair take place?
Yes, ma'am.
But without a DJ?
Without a DJ.
So you say you can't do it that weekend. They can't find somebody else. How did it go? Not well, according to you. It was dead because there was no music.
Yes, ma'am.
Okay, now, are supposed to play the next 2 days.
Right.
That are the next Saturday and Sunday.
The next weekend.
And what happens then? Let me ask you, Ms. Key, what happens then?
Me and Ms. Brown reached out to Mr. Clark during that week prior, asking him, was he going to be able to perform the second weekend?
And what did he say?
Okay, he assured us that he would.
Okay.
Okay, we let it go forward for him to show up for the second weekend. Mr. Brown did not show up for the second weekend. We still could not have any communication with him.
What does that mean, we didn't have communication with him?
We tried to call him. We could not. He would not answer no phones.
What happened the second weekend? Did you show up?
The second weekend, the Saturday, we proceeded to walk out of the door. It's drizzling rain. Saturday.
Drizzling means it's not raining much.
It's not raining much, but in the forecast it was saying rain.
So you didn't show up?
No, I didn't show up.
Did you call them and tell them? Wait a minute. Did you call them to see if it was still on? Did you call them to tell them, listen, it's raining too much for me to, do you have a tent? Do you have some alternative arrangement?
When I called, I didn't get an answer. When I reached out to them, I did not get an answer. Okay, and mind you.
Stop talking 1 second. Now I'm going to read to you from your answer to the complaint. That Saturday morning, it was drizzling. We're not setting up equipment in the rain. I didn't think they were going to be going ahead with the fair that Saturday.
Right.
And I will take fault for not reaching out to them. I waited to hear from them.
Right.
What do you mean, right? That is the opposite of what you just said in my courtroom under oath. You just said, I called and I couldn't get through because you know that this is critical.
Right.
This is critical.
It is.
Yeah, you just blowing them off is a problem. Because now there's a second time where you're being, the first time you have a great excuse, obviously, you have a medical reason, and they're still willing to, they're willing to, okay, no problem, we're still, let's go forward on the other 2 weekends. They're willing to, but then you don't call and choose not to show up without calling the employer and telling them, listen, there's a problem. If we're not under tent, if we're not under roof, I don't want to set up my equipment. I don't want it to get wet, whatever. Say something.
Right.
You do not call them. That's what you've always said. You just changed your testimony for the first time in here saying I couldn't reach him. Did you get a call from them? Did you get a call from him?
No, ma'am.
Do you ever hear from him? And if so, when do you finally hear from him?
Me and Miss Brown heard from him after the second weekend.
Yeah, when? I'm asking you when.
I'm not sure. I don't know if that Monday or Tuesday.
Okay, so it was completely after that weekend was over, according to you, is the first time you hear from him. And what happened?
21st. Miss Brown had us on a conference call. We spoke to him about it. He wanted to work the last weekend to make up for the first 2 weekends that he had missed. We told him that was not acceptable. We had talked over with our board members, and we said we could not rely on him. He had messed up the last 2 weekends. We had went out and hired another DJ for that
Did
final
another
weekend.
DJ come and play the last weekend?
We did hire another DJ for the last weekend. He was not able to play because, unfortunately, yes, we were rained out this year.
Now, this is about the $350.
Yes, ma'am.
And right after that third weekend, there is discussion, I presume, between you and him or Annette and him, about him returning the $350.
After the second weekend.
After the second weekend.
When we
and when does he agree? I know there's an email. Do you have that with you?
Yes, ma'am.
Let me see the date of that email where he says, I will return the money. All right, so here's the date, Friday, June 26th. That is that when the third weekend was what?
The 27th, 28th.
Right, so it is before the third weekend. There is an email from you to Annette saying, subject, reimbursement. Just want to, in capital letters, reassure you that I will meet with you on Saturday, July 11th to give you a refund of $175 and the balance of $175 Friday, July 31st. If I am able to give you the balance sooner, in capital letters, by all means, in capital letters, I will do so. Again, I humbly, in capital letters, apologize, in capital letters, for my unintentional, in capital letters, regard for this matter. All the best to you and your future. Did you send that?
Yes, I did.
Okay. If it was good enough for you then, why should I look at things differently now?
Welcome back to the People's Court. Harvey Levin here in front of the TMZ Hollywood tour bus, by the way. So here's the question. The guy had gangrene, had to go into the hospital for emergency surgery. Is that an excuse? I'm going in the back. Is that an excuse for not performing under the contract?
I think if he can prove that he had that, that's an excuse to not do it.
So there's a gangrene exception to a contract. Is that what it is?
Sure, like medicals, things like that.
But it doesn't say anything about that in the contract.
Then he probably should have made sure that was in the contract before he... Yeah, you're right.
So there's no gangrene exception?
Yeah, forget it.
Okay, so I brought you around, going inside the courtroom.
The rain dates on the contract are indicated to them.
I don't know what you're talking about. All your contract says is rain dates to, let me use
available upon request.
Yeah, rain date made upon request.
Right.
Yeah, but you decided it was going to be rained out at a certain point in time and this just didn't show up.
Man, listen.
You didn't show up. It couldn't be reached. You didn't call out. You didn't do anything.
I did call out.
No, you didn't.
I did call out.
No, you didn't. It's right there in black and white in your statement the whole time. And if you had, why would you send an email on June 26th saying, I am so sorry for my unintentional behavior. I humbly apologize. Why would all that have been there? You know what? You have no answer because there is no good answer. If it was good enough for you then, the only thing that changes it, you decided you didn't want to return the $350. $350. Why are you suing for $48.99 additional today?
Because, ma'am, in order for us to hire the last DJ for the last weekend, we had to spend $48.99. Okay, we'll take the loss.
Yeah, because I'm putting you in a situation where you understand that's part of your deal with another DJ.
Yes, ma'am.
I'm putting you in the situation you want to be in, which is you didn't do the job, so I want all our money back. You don't get the $48.99, but you do get the $350 plus, of course, your court costs in coming to court to try to get that $350. Verdict for the plaintiffs.
Thank you so much.
Here comes the defendant. This is the DJ right here. Step on up here. What about how you handled this job?
I thought fairly well. I mean, a lot that what needed to be said wasn't, in which case it is what it is.
What needed to be said that wasn't said? You didn't give the money back. You didn't get in touch with them. You don't go up there. Back here.
Oh, I'm sorry.
Let's go. Yeah.
I did get in touch with them.
Yep.
I did get in touch with them.
You do a lot of DJing?
Yeah.
Let's hear that DJ voice. Go ahead. DJ voice. Here it is. Go ahead.
Is that DJ voice?
That it?
That's it.
All right. That's good. Right. All right. Head right down this way. Okay. Take your time now. How you doing? All right, so what's your feeling on this outcome here?
Me and the Fulton Affair are very happy with the outcome. He was very unreliable and very unprofessional. Lack of communication was the biggest part. And yes, we were very empathetic toward his medical emergency, because myself and Ms. Brown, who passed, were going through medical issues ourselves. So yes, we were sympathetic to his cause.
Right, you're going to have this event again in the coming year?
We are our 58th year, Fulton Art Fair, Inc. 58? A 58th year on the fence.
Who's going to be your DJ this year?
It won't be Joseph Clark.
Harvey?
Okay, Kurt, it is pretty simple. If you have a contract with somebody, a personal emergency, even if it's understandable, is not justification under the law for not performing under the deal. And that will do it for this case. Litigants for the next case on the way into the courtroom right now. Hi, this is Andy Katz, host of March Madness 365, presented by Grammarly. This week on the podcast, listen as we break down the latest AP poll and give you insights on my updated Power 36. Listen to March Madness 365 with Andy Katz, presented by Grammarly, wherever you get your podcasts. Grammarly is a secure AI writing partner that gives your team an instant first draft in a few clicks, not a few hours. Companies that use Grammarly save an average of 19 days per employee per year. Grammarly works seamlessly across 500,000 apps and websites. Get personalized, on-brand writing help everywhere your team works. Learn what better writing can do for your company at Grammarly.com. Grammarly. Easier said, done.
This is the plaintiff, Wayne Brown. He says he purchased a van from the defendant. The thing failed inspection. Then a month after he had it, the engine completely blew. Turns out the defendant had replaced the original engine in the van with a car engine. It was overloaded, and that's why it blew. Since the defendant never told him this, he feels he was rooked and is suing for the return of his hard-earned $7,000. This is the defendant, Rodrigo Rebello. He says he drove the van over an hour away to the plaintiff's mechanic to check it out before he purchased it. The guy gave it a clean bill of health, and he sold him the van. Now he blows the engine in the thing, doing God knows what, and wants to return the van? Is he serious? He owes this joker no money, thinks the judge will rule in his favor, and will send the plaintiff packing. He's accused of moving motors.
All parties, please raise your right hand.
Welcome back to the People's Court. Next case in the docket, the plaintiff bought a van from the defendant and says the engine blew, but the defendant says it's his own fault. It's the case of van go, and van doesn't go.
Thank you, Douglas.
You're welcome, ma'am.
Wayne Brown, you are suing Rodrigo Rebello for $7,000. According to you, your damages actually exceed that by several thousand. And what it's going to cost you to repair a lemon that you say he sold you. Tell me what happened.
Well, I answered an ad that he had on Craigslist for a commercial truck. Excuse me, that was for sale. I'm a contractor, and the truck is a old Verizon truck, so it has a generator and a compressor built right into the truck. So when we come and do a service for someone...
What kind of business are you in?
General contracting, so we do remodeling.
So you would have your own power?
we usually bring our own generator, but buying this truck, we would pull up with the truck, turn the generator on. Now we use our own power instead of using the homeowner's power, in case we trip a breaker or something like that, you know. So I inquired about the van. He ended up bringing it to a job site I was at. We couldn't get the generator to turn on. I said, I'm interested, but obviously not if it doesn't have its own power. A week later, he said he got it running, asked us to come look again. So we drove up an hour from where we live to where he lives, got the thing to turn on, but the generator wouldn't stay running. So he said he would take care of the generator. We'll get the truck working if you want to buy it. I said, I'm interested. I want to buy the truck.
This wasn't enough of red flags for you that twice now the thing doesn't work for its intended purpose for you?
Well, the truck runs, but the generator didn't. So
yes, twice.
Yes.
So if you're buying it just because of the generator, well, how come you don't move on? Are these rare?
Yes, they are. Okay. They're hard to find.
Okay. Was the third time the charm?
Well, the third time he dropped it off. He drove back down to a shop in Kingston, and I wanted to make sure the generator ran. So the generator ran.
What do you mean a shop in Kingston?
The shop that my mechanic shop.
Oh, you had him take it to your mechanic?
Yes.
All right, and then obviously his advice was go ahead?
Well, he said he took it for a ride and said it's going to need brakes, but it could just be because it's a heavy truck. It's a 12,000 GVW truck.
Okay.
I said, okay, well, I'll let him know. And I said, you know what? We'll buy it. Don't worry about it. The following day, he drives down to my house. That was on the 21st of March.
What was he asking for the 2000 GMC Savannah van with?
$7,500.
Okay, and then what happens?
He came, picked up the check, signed over the title.
Okay, was there a bill of sale?
Yes.
May I see it?
Thanks, sir.
Okay, who wrote this contract?
I typed it up.
Yeah. Okay, so here's what the contract says. I, Rodrigo Rebello of such and such an address, am selling my van to Wayne Brown of such and such an address for $7,500. Truck is being sold in working order and expected to pass Massachusetts motor vehicle inspection in accordance with Massachusetts lemon law. If truck does not pass the inspection, do you know what Massachusetts law requires? Only that if it fails to pass inspection in the first 7 days, and he has certain responsibilities, the buyer has to take it there and get it inspected, that if it fails, either you give him his money back or you help him pay for the repairs to the tune of 10% of the purchase price. It's capped at 10% of the purchase price. But apparently, you put yourself on the hook for more than that in this bill of sale. Because he's very smart. He writes it to, I don't blame you, to protect him. And what he writes is that you'll be responsible for repairs needed to pass inspection by signing this contract and the cashing of the bank check. Both parties agree to the sale of this dollar amount and the warranty that you are giving. But you're in here saying that you're going to pay to pass inspection. What if it's more than 10% of the purchase price?
So the car wouldn't start, the van wouldn't start twice. Kind of a red flag here. Would you buy that van?
Absolutely not. That's too much risk.
What if the guy said the van's worth $1,000, it'll give it to you for $400?
No, still not. I mean, it's practically worth nothing.
Would you buy that van?
Absolutely not.
How many times does the engine not have to start when you're looking at it before you say goodbye?
The first time is good enough.
And the fact that it happened 2 times and then he still bought it?
Then he's a dummy.
Dummy. Okay, going inside the courtroom. Secret word.
So you take possession of the truck and what happens?
Well, the 23rd we register it.
Okay. You bought it what day? The 21st. What day do you take it for inspection?
The 23rd. Okay. And it failed.
Okay. Let me see the failure.
All I have is
you best have the failure. You best have the failed inspection report.
What I have is the mechanics.
No, I don't want to see what things you decided to do to a car. I want to know what things you had to do to the car. Okay? That means I want to see the 1, 2, 3, 20 reasons you failed so that I can see how much of the bill that you paid was because of your failure. Mm-hmm. Because otherwise, a litigant could walk in here, have 20 things taken care of, and tell that poor sucker that he's got to pay for all of them. So show me the failure.
They didn't give me the failure on the printout. They gave me their invoice for it to pass inspection with the receipt.
Let me tell you how it works. You're in court arguing that the thing failed. And my needs are so simple. I'm not a difficult woman. Just prove to me it failed. You see? You got to prove to me it failed and why it failed in order to have any of that taken care of. Now, as I understand it, he comes to you and says what?
I brought my own bill of sale, but he denied on that because I could have sold as is. And until then, everything was perfect with this deal. He even offered me a job working with him after this happened. And what happened is after he's getting I fix all little things on this truck, which he sent me that copy of that. Never received a reject. Until then, trusting in this guy.
Why would you trust in him?
I was planning to work for him. All right,
we all make decisions based on what's best for us. At the time you needed the money, you wanted to sell the thing, you thought you might be working for the guy, and so what do? You end up sending him a check.
I only can offer you $500 for we settle this deal, and that's it. I choose to lose $500, but get this out of my plate, and that's it. Now,
you didn't want to work for the guy after that, right?
I don't want to deal with anything else. Okay. Exactly, because I'm probably.
All right, so
I'm not going to say.
Okay.
What happened is I did send a check. I got the.
Wait. When you told him I offer you $500, what did he say?
He agrees with that.
Okay, I'm sorry. How did he agree? Through text, through email, through
emails?
Do you have the emails?
I do.
Let me see them.
I'm going to send you 2 copies. The second one was about the job he was offering me to be working for him.
Rodrigo, I hope things are well. Here's the paperwork from the mechanic. Let this letter serve. So he never showed you that he failed inspection?
No, unfortunately.
So as we're all standing here, none of us know for sure whether he failed inspection.
No.
Dude, you wrote him an email saying you'd take the $500 and that it would be settled. It will be the last that you are responsible for the GMC van. And yet, after that, you are now not only suing him for the rest of what that $500 represented, which you settled, so why, but you're suing him for a motor because you later find out other things, right?
No, Your Honor. First, that was the only reason he would even send me the check is if I wrote that. He says he supplied the
Yeah, just like I looked at him and said, tough for you, tough noogies, because you gave him the warranty. Well, tough for you, tough noogies, because you entered into what we call in the law an accord and satisfaction. It's a contract that 2 people who are going to be litigants make saying, you know what, let's settle this. What do you think is the effect of a settlement? You get to cash a check, and then you get to march into court anyway?
Okay. He did rear brakes. He admitted that he only did rear brakes on this truck.
Mr. Brown, enough, okay? You're a mere mortal like the rest of us. And when we agree to end a case, that goes for you too, not just for everybody else in the litigation world. When you turn around and extract another $500 from the guy after you've already gotten it down $1,000, after you've already had him fix 500 different things on it because you know the guy's desperate to sell it, all right? And then after you bring it to your mechanic and your mechanic tells you it's a good deal because that's why you brought it to your mechanic, then after all that, you end up getting the guy to pay another $500 and you promise him that that'll be the end of the last year responsible for me for this GMC van. Yeah, I'm going to make you stick to that. That's the last he's responsible. Verdict for the defendant.
Wow.
Well, the plaintiff was still talking after the judge ruled against him right here. So what was it that you were still saying in the courtroom? Come on over.
The fact is, he sold a truck that he already replaced an engine, and we didn't even get to explain it. He said the truck has been run, being used by him every day for 3 years, yet he had an engine replaced from a truck and put a car engine in, but we never even got to discuss it.
Yeah, well, what about the $500 agreement that you offered him in the email?
Well, that was only so that we could get some money out of him, and then the rear brakes blew out.
That's a contract, though. That is a contract, and it's legal, and you're bound by it.
Yeah, well, actually, by the law in Massachusetts is when I asked for my $7,500 back instead of getting an inspection, that's what I should have gotten instead of a check for $500 in the mail.
Well, you got to stick to what you agreed to.
All right, guys, right this way.
All right, so you step on in here, and what's your feeling on what you just heard?
I think she's honest. At least.
She's honest?
At least everything came the way it should be. Because all the proofs we have, everything, he thought I'm maybe an easy guy to be taking money.
Did you realize what you signed with him? Did you read that deal where you agreed?
I read, but I didn't
You were obligated to do more than the law said.
I trust in the truck. I have fixed myself. I have the proofs, everything, and I have worked with the truck.
Read what you sign and understand it before you sign it.
Correct.
Harvey?
Okay, Kurt, if you make a bad deal, it doesn't matter that it's bad. You can't say to a judge, I made a really bad deal, Your Honor. You are stuck with a bad deal. And that will do it for this case. Litigants for the next case on the way into the courtroom right now.
This is the plaintiff, Evan Toder. He says he rented an apartment from the very stern, uncaring defendant. And now that he's moved out, he can't get the defendant to return a security deposit. He left the apartment clean. The defendant's impossible to deal with. And he's suing him here and now for the $780 he's rightfully owed. This is the defendant, Richard Fish. He says the plaintiff told him he was moving out on a certain date. Then 2 days before the move-out date said his house wasn't ready and he couldn't leave for another couple of weeks. He already had the place rented out with a new tenant. The plaintiff's emergency's not his problem because it cost him money, and that's why he's withholding some of the guy's security. He's accused of taking advantage of a tenant.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff rented an apartment from the defendant and says he was swindled. But the defendant says plaintiff needed to move quickly and it wasn't his problem, so he's keeping the guy's money. It's the case of security deposit 911.
Evan Toder, you're suing the Meadows Apartments, represented here by Richard Fish, for $780 that you were shorted in the return of your security deposit that, according to you, you're entitled to. Let me hear from you. What's going on?
Beginning of August, I notified the manager I'd be moving out. I purchased a house.
What day were you going to be moving out?
August 30th, 2015.
Okay.
And getting near that date, I realized I needed a couple of extra days. First time I bought a home, I'm remodeling and whatnot. I went and spoke.
Had you closed already?
Yes, I closed June 30th.
Okay. Had he rented it to somebody else?
I don't know.
Did he tell you he did?
When I went in the office, he said he did, yes.
So what happened to that person who thought you were moving out?
Well, you know what's funny, Your Honor, is I have a friend who still lives at that apartment, and I was there a week ago, and the apartment is still vacant. It's been vacant for months now.
Did you have somebody moving in on September 1st?
I did.
And what happened?
When Mr. Toder told us that the apartment he was not leaving, we went to those people and told them that we had another apartment that I could make available to them. And they didn't want that apartment. It was on the second floor. And they found other housing.
Did you have to return a deposit?
I did. They gave us a $200 deposit, which I had to return.
All because it was inconvenient for you to get out when you said you were gonna?
Well, Your Honor, I told him I could have been out the 2nd or 3rd. He told me I would have to pay the entire month's rent if I did that. I obviously wasn't going to agree to that. We bickered back.
So what did you do?
We agreed that I'd stay till the 10th. I guess that would give me extra time to clean up or whatever. And I'd stay till the 10th for $300, which he agreed to.
Did you agree for him to stay until the 10th for $300?
I did not.
Do you have that in writing anywhere, like a text or an email or anything like that?
I have a check made out to him for $300, which he cashed.
And that check was written when?
September 1st.
Okay.
Would you like to see this?
Yes, I would. And it was cashed when?
Less than a week later, 5 days later. And in addition, Your Honor, I have a video walkthrough of the apartment after I vacated, showing that it is clean, in good condition.
Do you have any proof that he agreed that this is all you would pay? $300?
No.
This proves that you paid $300?
Yes.
Right.
But if I was going to pay the entire month's rent, why wouldn't I just pay him the entire month's rent in that check?
Because you don't want to pay the entire month's rent. Because you want to stay only the days that you need to stay. And you don't want to pay for more than that, but you don't mind him meeting a tenant. I mean, because that's, see, the way the law works is if you're there one day, you've now cost him the month, especially in a situation where he has to return a deposit.
Which I told him if I'm going to pay for a couple of days.
You're just supposed to get out when you say you're supposed to get out. And just because, while I'm remodeling, it's not convenient for me to get, that's not okay. I'm stunned that you think it's okay, and I'm stunned that you're talking like it's okay. Like what?
Honor,
I'll get out when I feel like it, and then I'll pay just for what I used. You know what I mean? That's not how it works. Like, do you get that part?
Yes, I get that part.
Yeah, you got to go to a hotel and move your stuff into where it be inconvenienced. Not they got to be inconvenienced and eat it, and then you're suing them for it. Now, you're also keeping money for cleaning. According to him, he left the place very clean. You have a video of it?
Yes, ma'am.
Okay, hold on to that 1 second. And let me just ask you, what didn't he leave clean?
There were, I don't know what it was, but there were some kind of stains all over the walls. The place was filthy.
Prove it.
Beyond.
Do you have pictures?
I don't have pictures because I didn't think at the time there was going to be any kind of lawsuit.
Okay, I don't know why, because if you walk into a place and you see stains all over the walls, all right, and you're going to charge a guy for it, and you already know he's fussy, he's not just going to walk away because you've already had an argument with him about him staying in September, how would you not think it's a problem and take pictures? In fact, did you hire a service to clean?
Yes. Okay,
because I'm looking at the receipt that you've provided into evidence, and what it says is pictures available upon request. So why didn't you request them for court?
So by cashing the check, does the landlord forfeit the balance of the rent?
He could possibly, by cashing it, I think it might show that he's accepted that as the...
Well, that's my question. Yeah. Does it? Does it?
I don't know. I don't think so.
So he can still go after the remaining 20 days?
That landlord, I'd go after my 20 days.
You may do it, but by cashing the check, does he screw up his rights?
No.
Last word?
No.
That's it? Okay, I wasn't literal about one word, okay, going inside the courtroom.
Let's see if I have evidence of it. Let's see your video. Let's see if it buries you or exonerates.
Just press the play button, I walked through the whole apartment.
This is the living room. Kitchen. Bedroom.
The amount of the security deposit was $1,177.50. Everybody agrees?
Right. I have $1,162.50.
Can I see the lease? Do you have a check?
Cancel check from it?
Yeah.
No, it was...
All right. Oh, the difference is the $15 key deposit.
Correct.
Oh, did he return the keys?
Yes.
Oh, okay. All right, $1,177.50. All right, now, he ends up, in addition, giving you $300, and you did cash that check.
I deposited it into the account, yes.
Okay, well, yeah, you cashed it. All right, but according to you, you never agreed with him that that is all he would pay in rent for the month of September.
No, I didn't agree with him at all. He came into my office a day or so before he was leaving. We got into a discussion about him moving out. And I said, your apartment has been rented. If you don't move, I said, I'm liable to these people. I'm going to sue you. And we got in a big discussion, and he left. He came back later and said, I will be out. He said, draw something up. I'll sign it. I'll be out by the 10th of the month. I said, fine, that's what I need.
Can I see that?
Sure.
You folks drew something up?
Yes.
Oh, that's
well,
kind of
what
important.
was drawn up actually just said I'm giving him $300 through the 10th. Doesn't really say I'm going to be out the 10th, but I was actually out the 4th.
I will be completely moved out of apartment on September 10. Okay, but where's the part about and all I will pay is $300? Where's that part? That's not in there.
Well,
okay.
I guess
so where's that? That's pretty critical. If, like, supposedly you guys came to an agreement, which I would find hard to believe in his circumstances. You trusted him.
Yes.
No,
my
listen,
mistake.
honey, the problem here was that he trusted you. That's where the problem was. Because you're kind of a selfish guy. Like, you don't get the idea behind the commitment of you need to move out. Like, if it's not convenient for you, you're just staying, and everybody else can go scramble and figure it out. And I'm not even talking about him. That's bad enough. I'm talking about the people who thought they had an apartment. And now they've got to, on, you know, the day before they thought they were moving in, they've got to go hustle to it because you're just not ready. Okay, I got it. So no, you owe the month of September. Now, the month of September is $790. Is that correct? That's the monthly rent? All right. But without you being able to prove, because his video, I mean, I can see some marks on the wall. You know, his video's you want to do that slower, unless, of course, you don't want to do it slower when you're going past that. But I love the fact that he brought a video, and it's way more impressive than you bringing me nothing to prove that you're entitled to keep $300. So I'm going to allow you to keep the $100 that the lease says is the minimum cleaning fee that he will be paying, because the lease you signed does say that. And the $790 for rent, so that's $890 from the 1177.5, no, from more than that, because he paid you $300. So it means that on your side, there's $1,477.50, right? With the $300. Minus $890 which is what I find that you are entitled to keep. I am ordering you to return the remainder of that, which is $587.50. Did you cash, and did he send you anything or no?
Yes, he sent me a check for, I believe it was $387.
Did you cash it?
Yes.
Okay.
It was $387.50, Your Honor.
Minus $387.50 equals the $200 discrepancy. And therefore, I am ordering you to pay Mr. Toder the $200 discrepancy that you're unable to prove you're entitled to. Okay? That's my verdict. Good luck, folks.
Ma'am, my phone?
Yeah, bring it up. I'll take it.
Well, the plaintiff's out of the courtroom first. You'll be paying the whole month of September and everything. And step next to me here and tell me what's your reaction to this outcome and how this case made you look.
Kind of surprised. I thought I'd get part of that rent back, but, you know, it turned out the way it turned out. I mean, I guess she was fair. I got the cleaning back, and he got to keep the rest of the rent, so.
What about just making a decision at the last minute and leaving the other party hanging who's planning on moving into that apartment?
I can understand that. They have a place that they, you know, need to rent to somebody else, and it's business, so.
Okay. All right, right down.
That's why I bought a house.
Okay. He bought a house. He doesn't deal with landlords anymore. What's your reaction to this outcome?
I'm fine. I expected the extra $200. The place was a real mess, but it is what it is. It's the type of person he was.
What type?
I'd rather not say.
What do you want to say?
I don't.
Harvey?
Okay, here's a little trick for you. If you write a check for somebody and you want to make sure that that's the only amount you have to pay, turn the check over, and on the back, right above where the person would endorse it, write the words "payment in full." Those are magic words. If the landlord cashes it, that's it.
Hi, this is Andy Katz, host of March Madness 365, presented by Grammarly. This week on the podcast, listen as we break down the latest AP poll and give you insights on my updated Power 36. Listen to March Madness 365 with Andy Katz, presented by Grammarly, wherever you get your podcasts. Grammarly is a secure AI writing partner that gives your team an instant first draft in a few clicks, not a few hours. Companies that use Grammarly save an average of 19 days per employee per year. Grammarly works seamlessly across 500,000 apps and websites. Get personalized, on-brand writing help everywhere your team works. Learn what better writing can do for your company at Grammarly.com. Grammarly. Easier said, done.